course, I spilled coffee on my shirt, but oh well.
I just spilled some on my desk. Welcome everyone again to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science by experts in behavioral health and the law, hosted by the University of New Mexico's Department of Psychiatry and Behavioral Sciences, along with the New Mexico Behavioral Health Services Division. Thank you all of you for joining us today. I'm Anthony Perillo, the Forensic Training Director in the Division of Forensic Behavioral Sciences here in the University of New Mexico's Department of Psychiatry and Behavioral Sciences. For our talk today, if you have any questions for our presenters, make sure you enter them in the Q&A box anytime you feel comfortable. Know that we do hold those until the end. We do try to get to as many as we can. Just forgive us if we don't get to yours. There may be some prompts during this talk, and your presenters will let you know if they want you to enter those in the chat box or the Q&A box at that point. If you are pursuing continuing medical education credits, there will be a sign-in sheet posted in the chat box shortly. And those of you that are pursuing APA continuing education credits, there will be a link posted in the latter portion of the talk in the chat box. So keep an eye on the chat box. Make sure you open that link to test it. Make sure it works before you leave the webinar. Make sure you save your certificate after you complete the survey too, because we don't have access to those surveys after the fact. A recording link and PowerPoint slides for this talk will be available sometime later this week. And for next week's talk, that is still to be determined. We'll try to update you as soon as possible. We had a late cancellation and are trying to put things together for a talk for next week. Again, we will try to keep you posted as soon as we can. But let's get back to this week. I'd like to introduce you to today's speakers. We'll be discussing multiple relationship issues in forensic psychology. This is Dr. Michael Gottlieb and Dr. Jeff Younggren. Dr. Gottlieb practices forensic psychology in Dallas, Texas. He's board certified in family psychology, a fellow of the American Psychology Law Society, and a clinical professor at the University of Texas Health Science Center in Dallas, where he teaches professional ethics to doctoral students in clinical psychology. He's past president of the Texas Psychological Association, the American Board of Family Psychology, the Academy of Family Psychology, and completed terms on APA's Ethics Committee and Committee on Professional Practice and Standards. He's consulted or testified in 20 states, 5 federal jurisdictions, and has written or contributed to over 80 peer-reviewed articles and book chapters. Dr. Jeff Younggren is a forensic psychologist who practices in Albuquerque, New Mexico, and is currently as a clinical professor in the Department of Psychiatry and Behavioral Sciences at the University of New Mexico. He's a fellow of the American Psychological Association and a distinguished member of the National Academies of Practice. He's served on numerous boards and committees, including the Council of Representatives of APA, the Ethics Committee of the California Psychological Association and the APA Committee on Accreditation, the Committee on Practice and Standards of the APA-APLS Committee that drafted specialty guidelines for forensic psychology. Dr. Younggren consults to various licensing boards on ethics and standards of care and qualifies as an expert in criminal, civil, and administrative proceedings. He continues to this day to serve as a risk management consultant to the trust and its policyholders. Dr. Gottlieb, Dr. Younggren, on behalf of the University of New Mexico, thank you so much for joining our series. Very excited for you to be discussing this in your areas of expertise and sharing all that you have to offer us today. I will go ahead and throw it over to you.
Thank you, Anthony. So these are the CE requirements, the materials with regard to CE. You all have seen these many times. This is the statement that we have no conflict of interest, and we were searching for one and we couldn't find one, and so we are conflict free at this point. And the disclaimer that these views are our views and are not the views of the University of New Mexico or its policies. And so with this, I'll turn it over to Mike.
Okay, thank you. And they are also not, my views are my own and don't represent those of UT Southwestern either. Okay, learning objectives. First, we want to review the relevant ethics code provisions and specialty guidelines that address the issues we're going to talk about. Next, we're going to try and discuss the relevant ethical issues that arise in forensic contexts. And third, try to better understand the conceptual and ethical decision-making that's involved in forensic settings. In other words, we're going to try and go beyond the code and beyond the specialty guidelines and try and, at least out loud, think through some of these issues in a more in-depth fashion.
So one of the things we want to invite the audience to do is to participate in a discussion as we move through these topics, because they are at times controversial, and sometimes there is no clear road to the right answer. And that's really why we chose the title that we chose, because one of the things that seems to exist out there is that if there is in fact a dual relationship, forensic or otherwise, it is automatically some kind of ethics or legal violation. And that is simply not the truth. That dual relationships and multiple relationships exist all over the place. They are a part of of human existence. It's impossible to live in a sterile environment as a therapist or as a forensic expert. And so, given one, that the dual relationships naturally exist, it becomes a question of how to manage them. And so Mike and I thought that we would start with a little discussion of Bloom's taxonomy. Some of you who have attended workshops with the trust have seen this before, but I actually think that Benjamin Bloom, who put the taxonomy together, was right on in terms of suggestions about how we should think about the problem areas that face psychology, and specifically about issues that have to do with duality, if we can use that term. And so Dr. Bloom was a psychologist, and what he kind of separated learning into two categories. One is like a lower order rule-based kind of learning that really has to do if you understand something, you know the rule, and you understand the rule and you apply it. And an example of that would be that if you were at a stoplight and you knew that the stoplight was red and you were supposed to stay there till the stoplight turned green, then you understood that rule and you applied it and you sat there until the light turned green. And that's the lowest level of intellectual decision making that exists. But the problem is there are exceptions to that. For example, if the stoplight is broken, you're sitting there waiting till the light changes, which is never going to happen. And then the paper will publish an article about how a psychologist starved to death sitting at a stoplight where the light was red and it was broken because the lowest level of learning occurred. But that's not really where it's at. It's not really what we're about, and it doesn't apply itself well to the concept of dual relationships in forensic practice. And the higher level of learning and understanding has to do with analyzing the rule system and synthesizing your understanding and then applying that in some evaluative way to a decision making. And that's really what we're about today, is to talk about decision making in dual relationships in forensic practice. Because of course, you're sitting there after a while and the stoplight's still red and you go like, well, this is broken. Well, you've just analyzed it, you synthesize that, and you make an evaluation, you drive through the stoplight, right? So that the first order is concrete decision making. Easy peasy, right? You always go 35 miles an hour. You never take a gift from a patient. You never allow a lawyer to tell you what to testify about. You just do these things concretely. But the fact is, it doesn't apply to every circumstance. And so you need to understand conceptual decision making. And those of us who find ourselves in courtrooms frequently have to make decisions about the circumstance within which we find ourselves. So what we've tried to put together here for you is some vignettes to stimulate the discussion about dual relationships. And we titled this carefully because there are lots of myths about dual relationships. Immediately, if you have a dual relationship, it's unethical. Well, everyone knows that's not true. Dr. Gottlieb, Mike has written many articles about this, and we've published together in this area as well. So let me take you to a couple of examples of risky dual relationships in forensic practice. So let me see if that works. So I'm gonna have to.
Is it my turn now?
No, not yet.
Oh, okay. Well, one more thing before you go
your
on, Jeff. I think that the take-home message, and you're probably going to hear it from us a half a dozen times during this hour, the fact that there is a dual or multiple relationship is not necessarily unethical, because the issue is whether or not the circumstance presents a conflict of interest. And that's going to be the issue that we're going to discuss.
Right, right. Which requires you to understand conflicts of interest. At the lower level of learning, you go like, well, it's a dual relationship, therefore I should avoid it. But that's not correct. And there's no way around duality. This is simply a part, as I said earlier, of the world. So let's talk about Dr. Marshall here and see if this stimulates a little bit of commentary from the audience that's watching this. Dr. Marshall is a forensic psychologist who evaluated a defendant for the defense in a criminal case that involved alcohol use and assault. After completing his evaluation, he found out that the expert for the prosecution was going to testify about the impact of alcohol on behavior, a topic for which Dr. Marshall has qualified many times. He also found out that the substance of the proposed testimony by the other expert was scientifically incorrect. The defense attorney wants Dr. Marshall to testify both about the results of the evaluation and about intoxicated behavior. Dr. Marshall takes on both. I can't see this, it's blocking off my, can you read that last line?
Yeah. So the question, Jeff, would then be, why should Dr. Marshall not do that? Because I know some people would be concerned that he shouldn't be doing that.
Yeah, exactly. It really is. Is this a role shift? Yes. Is it unethical? Why? If Dr. Marshall is an expert in the area of alcohol and pass out, blackout, and so forth, and the other side is going to put an expert on to discuss that, why should Dr. Marshall not be allowed to testify as a subject matter expert in the proceeding, given the fact that he in this case, has already done an evaluation of the individual who is the defendant in the case?
Now, what we've left out here is that we don't exactly know what the substance of the proposed testimony would be. In other words, why is it scientifically inaccurate? Is it because of this concrete information that Jeff's talking about, or might it have to do with the procedure they followed?
Right. And frequently people will say, based upon their rule-based experience, that this should be two experts. And I would say, you need to answer the question for me as to why does it have to be two experts? What's the difficulty with Dr. Marshall testifying in both roles? Are the roles different? Yes. But are they an ethics violation? And I think you need to carefully analyze that. You need to understand where the conflict of interest might be. Is it a loss of objectivity? Is that an issue? Is bias an issue? Anthony's talked about this before. You know, what exactly is the circumstance under which Dr. Marshall should not be allowed to testify?
And there is at least one possibility where that could be. For example, if Dr. Marshall feels strongly aligned with the defense lawyer and then reads the government's, pardon me, the government's report and maybe finds that it isn't quite as bad as he thought to begin with, is he going to feel the tug to perhaps criticize the report when in fact perhaps he shouldn't, because he feels an excessive loyalty to the defense lawyer?
Right. And there's another consequence that comes out of this kind of bifurcation of roles, which is that frequently lawyers simply cannot afford to have experts to occupy each of these separate roles. It may be true in a civil case where an insurance company is paying for the experts, but in the realities of the world, that really is quite difficult to accomplish from a financial perspective. So is that creating a just circumstance for the defendant to create these separations? So complex situation and requires some complex decision-making and thinking. Anything else, Mike?
No, I think that's it.
All right, let's go to the next one, see if I can get it to advance. And it's not. I did it. This is a more complex case, but should stimulate some discussion by the group. Dr. Wong is a forensic psychologist who has been hired as a trial consultant in a civil manner. She reviews all of the case materials and gives feedback to the lawyer that some of the evidence is helpful to the case and other evidence is not. The lawyer wants Dr. Wong to testify, but to emphasize the favorable factors only. This is not unusual. This happens frequently. That would be the mission of a defense attorney or of a prosecuting attorney to further their case. And so the data that Dr. Wong may bring may not be, it may be helpful to the psychology, to the trier of fact, but the lawyer, of course, wants to accomplish the mission of furthering their goal of being an advocate for their side of the case. Dr. Wong says that as a matter of transparency, she has to disclose all the information she reviewed and asks the lawyer how she wished to proceed. All right. The lawyer insists that Dr. Wong only testify about the favorable evidence, even though the prosecutor has Dr. Wong's notes and states that they will only ask questions in that direction. Comment, Mike?
Well, I think the one thing we just need to include, just as out of an abundance of caution, is that usually when witnesses are qualified, they're asked by the attorney who called them what documents they reviewed. And part of the issue here is that Dr. Wong is going to have to explain and read into the record all of the things that she reviewed. Whether the defense lawyer asks her about certain things or not is up to the lawyer, but she still has the obligation of being transparent and explaining to the trier of fact exactly what she reviewed, regardless of what the content might be.
So the lawyer objects, and Dr. Wong then agrees, but strongly suggests the adverse information be disclosed on direct. The lawyer disagrees and says that they will handle the cross. Hoping to please the lawyer, she finishes her direct and realizes that the withheld information may be revealed on cross and feels a need to please the lawyer by minimizing the disclosure of adverse information. The case has become problematic here. That's clear that Dr. Wong has engaged in some bias in this matter. And actually, one of the good things about the courtroom is that regardless of what this Dr. Wong wants to do or doesn't want to do, the cross-examination is the cross-examination. The attorney on the other side has the responsibility to do what he or she wants to do. And so I always believe that when we get into these mixed roles, or when we get into matters of potential bias, or most of you have been in circumstances where you've seen another expert, I'll use the term spin something in one way or another, that I believe that it is the function of cross-examination to straighten that out. and that the expert consulting on the other side needs to help with that information. So Dr. Wong is in a precarious position, which is that she is cursed with the human condition, which is that she's not being entirely objective, and she's being thrown back and forth by the forces of the dynamics of a courtroom situation. Does this worry me? Yes, it does worry me. It does. Is Dr. Wong supposed to now recuse or get herself out of the situation? Good for discussion? I don't think so. I think that the cross-examination is where the road to the truth, and this is going to come out in the cross-examination. Mike?
Yeah, I want to drill down on this just a little bit further, because I think Dr. Wong has done everything that she was supposed to. She told the lawyer she had to she had to list all the information she reviewed on direct. She told the lawyer that some of this was going to come out on cross. The lawyer then, perhaps inadvisedly, says to her, "Oh, don't worry about that. I'll handle that," which of course I'm sure we've all heard before. And if she explains to the lawyer that the adverse information is going to be disclosed, and the lawyer chooses not to do it, she may have done everything she could up to that point. The question is whether or not there's an intervening step here, which is whether or not Dr. Wong would then say to the lawyer, "Look, we need to talk about cross. We need to talk about what they're going to ask and what I'm going to say, because if you think you can handle it, that's fine, but you need to know what I'm going to testify about." So part of the problem is that Dr. Wong has put herself in this situation, I think, at least unnecessarily, because now she finds herself in what some people would call an internal conflict of interest, where she is trying to please the lawyer by, as Jeff says, spinning the testimony, which she clearly shouldn't be doing. So I think part of the problem is that Dr. Wong could have taken an extra step and talked about cross with the lawyer before testifying.
Right. Okay. So let's go to the principles, Mike.
Okay. So I'm sure you're all familiar with these. We will not take a lot of time with them, but we start with 2.04 from the code, which is that our work is based on scientific and professional knowledge. In other words, this is what we sometimes call scientific responsibility. So the first issue is, do we present our data in an honest and open and objective manner consistent with the findings, which usually means that sometimes lawyers don't like that, because in science is probabilistic and there's always another hand. So one of the things that lawyers sometimes need to get used to is the fact that we can't necessarily answer questions definitively because our data is based on probability. But the issue is that when people find themselves in conflict, sometimes they want to please the lawyer and perhaps scoot over that line and not adhere to the scientific knowledge quite as precisely as we'd like. Jeff?
Yeah, I think that that's a really important point, is that I have taught for years and strongly believe that a real expert, a truly objective expert, doesn't have anything different to say for either side. And I have liked proceedings. I've done lots of military trials, and in military trials, when you get hired, you frequently don't know which side has hired you. And I actually like that, because if science doesn't take sides, then you're going to be an expert serving a trier of fact in a court proceeding, and you may end up being on the defense, or you may be going to end up on the prosecution side. Now, in civil and criminal outside of the military and federal cases, you know who hired you, and frequently people are shopping for experts who will address issues in their direction. I get it. I mean, because of course, while science doesn't take sides, science also is a world of probabilities, and there are outliers to scientific positions, and those clearly will impact what somebody can say or not say in a courtroom. And I go back to my earlier thesis, which is cross-examination. I've testified 400 times, and I've learned over the years that if you stay in your lane, cross-examination isn't a miserable experience. And if you don't stay in your lane, and if you don't continue to work with this scientific and professional judgment perspective, I think lawyers can smell it. And then you have a miserable experience on the stand. So stay in your lane, and it tends to work fine. Be objective, stick with the science, stick with the professional regulations and rules, stick with the guidelines, and you're going to avoid having a negative experience, which can impact you personally and professionally.
I actually had a lawyer call me once, and I believe he was a plaintiff's lawyer in a civil matter. I think, I don't remember exactly, but he basically told me what he wanted. And when I said to him, well, I really can't do that, it's unethical, he said, well, I don't know what makes you think it's unethical. I've hired psychologists to do this for years. At which point I said, well, I'm sorry, it's still unethical. At which point he hung up on me.
Yeah, rejection's painful, but the right answer, right? Okay, the next one's yours.
Okay, so this is 3.05, multiple relationships. A multiple relationship occurs when a psychologist is in a professional role with a person and one, at the same time is in another role with that same person, two, at the same time is in a relationship with a person closely associated with or related to that person with whom the psychologist has the professional relationship, or three, promises to enter into another relationship in the future with the person or a person closely associated with or related to the person. By the way, number three, for those of you who aren't old enough, was really as a result of sexual misconduct. And then the second point is a psychologist refrains from entering into a multiple relationship if the multiple relationship could reasonably be expected to impair the psychologist's objectivity, competence, or effectiveness in performing his or her functions as a psychologist, or otherwise risks exploitation or harm to the person with whom the professional relationship exists. So in a forensic context, most of this is not particularly relevant to what we do, but the fact that you are A1 in the same or in another role with the same person technically could be construed as a multiple relationship. But the question becomes, is it unethical? Multiple relationships are a type of conflict of interest. So with A1, the question is whether or not you are in more than one role with this person is not the answer. It's just the beginning of the analysis, which is, does that in any way cause me a conflict of some kind? Going back to our earlier example, the question is, if I have an issue with a lawyer where I think they're going to be unhappy with me, could that put me in an unacceptable multiple relationship? If I compromise my scientific standards and don't testify honestly, yes, of course it could. The other side of the coin is, if you have the ability to sit down with the lawyer and say, look, here's how it is, here's what I can say, here's what I can't, and the two of you work it out between you, then you may be in another role with that same person and not be in a conflict of interest.
Yeah, I entirely agree. I mean, I think that this first section A is informative. It describes the nature of human interaction, but this is where we get mixed up. But this is because you meet the requirements of 3.05A doesn't mean you've committed an ethics violation. People interact with other people all the time in different ways. And having done with many of these cases and many of these consultations, I've run into individuals who say that if you're doing a forensic case and you have dinner with the lawyer to discuss the case, the mere fact that you've had the dinner is an ethics violation. Or if you take a gift from the lawyer at the end of a trial or for the holidays, or if there's a lot of discussion about this. So what it requires the person to do is to stand back and say, am I being objective? Am I still able to carry the water on the questions I'm supposed to deal with? We live in a social world. We are social beings, and the social relationships are a reality. Lots of publications about this small town issue. Lots of cases have discussed how when you're in a circumstance where there are limited resources, sometimes the fact that there is a social relationship is unavoidable. And it doesn't necessarily mean that it's a conflict of interest or that it has impacted your competence and effectiveness. And we'll talk about some of the ways to manage this better a little bit later on. But this is where I have lots of difficulties, because I believe that lots of graduate programs spend a lot of time scaring people to death about this area, when in fact there is a way to manage this. That we really need to understand that the human relationships are not a curse of human existence. They are a key part of human existence. And so it's what you do with it that's important. As I said, I really worry that young psychologists coming out of graduate programs get risk averse from their ethics classes. And really, that's the wrong direction. And we want people to think. We want you to stand back, analyze the circumstance, and think about it. The mere fact that
Well,
you
Jeff, I
had
got a question
was
for you.
say again?
Let's drill down a little further. This just occurred to me. So
Sure.
let's say you get asked by an insurance defense lawyer to evaluate a plaintiff in a civil matter, and you have an opinion which is favorable. Then the lawyer comes back to you and says, hey, I got a report from plaintiff's lawyer, and we think there's a bunch of stuff in here which is unethical. Can you testify about that too?
Yeah. What do you do?
Well, for example, you could say, no, you need to hire another person because you need an ethics expert who can talk about the forensic standards. I've only evaluated the plaintiff, for example.
But what if you also are an expert in ethics?
Well, from the purpose of my example, we're going to assume that person is not.
Okay. Yeah, but I think people should be familiar with the standards of professional practice. I mean, sometimes the mistakes made by other individuals are glaring. And is it, and I'm just doing this rhetorically, I mean, is it the right thing to do to know that this is a glaring mistake and then say to the attorney, but you need to hire somebody else to address that? And is that a role conflict? Is it appropriate or allowed for the individual to say, well, this other report or whatever it is a hot mess? I mean, it's a really an important question, and I'm not sure we have the cutting edge answer. Of course, if all things were possible, if funding wasn't an issue at state levels and all those kinds of things that are realities, and purity was what we wanted, we would not have one person do that. But is that, in essence, unethical? And I know this is going to raise a number of comments from individuals with whom I've debated this in the past. I don't think it's ipso facto unethical.
Okay, but the question then, Jeff, and I think you'd need to discuss this with the defense lawyer, is okay, so on cross, what do you do with the question of, oh, so you evaluated my client and you think they're a hot mess, and now because you think that, you need to say that my expert's report is flawed too?
Well, it's definite bias, right? At least an allegation of bias.
Exactly.
And can you answer that?
Well,
I think the issue is, as a forensic expert, can you answer that and explain how that's not the case?
Well,
I
would go a step upstream and say, I think if the lawyer wants me to have that opinion about the quality of the evaluation from the plaintiff's expert, I would need to have that discussion with the lawyer and explain my vulnerability on cross to the allegation of bias.
Okay. All right. Well, we got a few responses out there. I'm sure some people. I want to acknowledge to everybody, the easiest answer is to say you just get another expert. I'm not sure that always works very well. I'm not sure that is at times economically feasible.
Well,
But
all I can tell you is that I do a lot of court-appointed work in criminal matters, and I promise you it's not feasible.
so what do you do? So
Well,
then,
again, you got to discuss it with the lawyer.
yeah, I agree. I don't disagree. All right, we'll go to the next one. This is yours.
It's not up yet.
Yes, it is.
Oh, I'm sorry. 3.05, multiple relationships. Multiple relationships that would not reasonably be expected to cause impairment or risk of exploitation or harm are not unethical. This is the point that we've been trying to make. So 305B, if a psychologist finds that, due to unforeseen factors, a potentially harmful multiple relationship has arisen, the psychologist takes reasonable steps to resolve it with due regard for the best interests of the affected person and maximal compliance with the ethics code. I think that's exactly what we're talking about when we emphasize the fact that when issues arise, whether they're necessarily going to be conflicts or not is one thing, but you need to discuss your position with the lawyer to make sure that he or she understands exactly where you are and what you can and cannot say. And then to some degree, it may be up to them, assuming it's not going to be unethical for us. 305C, when psychologists are required by law, institutional policy, or extraordinary circumstances, whatever those are, to serve in more than one role in judicial or administrative proceedings, at the outset, they clarify role expectations and the extent of confidentiality, and therefore, as changes occur. This is more complicated, and this is the place where I think Jeff's notion about working in rural areas really becomes a problem. I did a case once where a guy had been asked to do a custody evaluation for some parties, and he did, and he completed the work. And then the court asked him to serve as a mediator between the parties to see if he'd get the case resolved, and he agreed. The state board in that particular jurisdiction decided that was not okay. Now, one could argue that this was an extraordinary circumstance where he would have a reasonable basis for mixing these roles in a clearly unacceptable way because he'd already rendered an opinion regarding one of the parents. I think the issue is here that he failed to explain to the court his conflict and explain to the court, look, Your Honor, I really can't do this. I've already had an opinion regarding the custody in this case. You're placing me in an unacceptable conflict, and I'm going to have to respectfully decline. Now, I don't know why he didn't do that, but I suspect it's because he and the judge are good buddies. The judge sends him a lot of work. It's a smaller community. He doesn't want to, how shall we say, hurt his own circumstance. That's my guess. I don't know. But the point is, this is one of those situations, especially in rural areas, where there's a shortage of qualified people, where this becomes a real problem. Yeah.
Yeah, I wanted to expand just briefly on that, and then we move along. I don't want to run out of time here. Is lots of times people don't even understand what a forensic role is. So, I mean, frequently treating clinicians get themselves in a pickle when they write letters, evaluative letters, positive opinions about parenting skills, and write long-term disability configurations for their clients, because it's a role conflict. It's a role conflict, and in many ways, I would say, as a forensic, it's a dual relationship, and it's actually a violation. And so we run into problems over and over with that, is that people not understanding that there's a time when you say, I can't do that. And that you make known that you can't do that, both to the lawyers that you work with, as well as to the people who consume your services. Treating clinicians are 99% of the time do a great job of saying, no, my job is not to write the letter for you to get a disability payment beyond the emergency circumstance within which we find ourselves, because that is an administrative forensic function. It's not something I do as a treating clinician. So recognizing what your role is so key to actually avoiding getting yourself into difficulties. Okay. So let me talk to you a little bit about This is one more. This one's yours, Mike, right?
I don't remember, but I'll do it, or you can, either way.
You can do it. I have faith in you.
This is 1.02, conflicts between ethics and law, regulations, and other governing legal authority. Pardon me. If psychologists' ethical responsibilities conflict with law, regulations, or other governing legal authority, psychologists clarify the nature of the conflict, make known their comments to the ethics commitment to the ethics code, and take reasonable steps to resolve the conflict consistent with the general principles and ethical standards of the code. Under no circumstances may this statement be used to justify or defend violating human rights. This is a situation that arises in a very large number of situations where there isn't necessarily a conflict with law, but there is a conflict regarding our ethical issues. I mean, the one that Jeff just raised is a perfect example. Years ago, there was a situation where VA psychologists who were treating veterans were being asked to weigh in by evaluating them for disability. This is a perfect example of where, even if there isn't any specific law that you're violating, this is still a huge problem. Now, in another case, I had a former student who went to work for an agency and was asked to sign off on the insurance forms for all of the staff who weren't psychologists. They were social workers, and they were seeing these people. And his supervisor asked him to come and sign off on all the insurance forms as if he had been supervising these people, when in fact he hadn't. Clearly, this would be a legal violation, and as a result, unfortunately, he found himself in a position where he had to resign. Jeff?
No, I think this is really a principle that's garnered a lot of attention, especially the last sentence of the principle, because this is in place because of the torture question about the military giving orders to individuals who could make you engage in torture, and APA has codified that under no circumstance can you be involved in something that violates human rights. I don't disagree with it at all. This has been a controversial principle, but I think that it's been a bit of a dynamic, and in light of the torture allegations, that's partially what's there. But it also puts the onus of responsibility on you when you find yourself in a conflict of interest in a dual relationship to make known that conflict, and you then have to resolve it in one way or another. So let's move on, Mike. I think we're going to run out of time talking too much. So these are mine. Specialty guidelines for forensic psychology. I was honored to be on the committee that wrote the 2013, and I'm on the current committee for the revision, which has been extended because we don't have an ethics code that's under revisions. We need to get that taken care of. But one of the things that's very important to remember is that by the Committee of Professional Practice and Standards, guidelines are simply, in many ways, aspirational. They're not enforceable. They're tied to the ethics code, and so you'll see the quotations in the guidelines, but as a single document, standalone, it is not in and of itself something that establishes legal conduct or enforceable ethical conduct. So from the specialty guidelines in forensic psychology, 2013, forensic practitioners refrain from taking on a professional role when personal, scientific, professional, legal, financial, and other interests or relationships could reasonably be expected to impair their impartiality, competence, or effectiveness, or expose others with whom a professional relationship exists to harm. So it's a harm-driven. In many ways, this is a rephrasing of the ethical principles 3.06, but it's interpreted for forensic psychology. As I said, these are aspirational, except in two jurisdictions. In spite of the fact that COPS has said that these are not enforceable, the state of Pennsylvania has incorporated them in their law as enforceable. And I think Delaware, I might be wrong on Delaware, but I know Pennsylvania is one of them. So there are two jurisdictions where, in spite of the fact that APA and our profession has said these are just supposed to help forensic psychologists operate better as forensic psychologists, those people in Pennsylvania need to heed this and be careful of it, because it's actually in the law. Let me do another one.
Yeah, the only well,
Go ahead.
the only thing I would add about that is that while Jeff is absolutely right, these are guidelines, they are not enforceable. It nevertheless represents the thinking of our colleagues about what best practices are. And it really is a good idea to follow them as a matter of good risk management and doing good work.
I don't disagree with that. I don't disagree with that. But I think that people 99% of the time need to understand they were written to be aspirational, but they're very helpful. There's no question about it. Why are they helpful? Because a bunch of people who have done forensic psychology all their lives have kind of gotten together and put these together to help the profession function better in a limited forum, that being forensic practice. All right, number 101, forensic practitioners strive for accuracy, honesty, and truthfulness in the science, teaching, and practice of forensic psychology, and they strive to resist partisan pressures to provide services in any way that might tend to be misleading or inaccurate. We talked about this, until we're blue in the face. This goes back to my original comment, which is that, science doesn't take sides, and a good expert doesn't really have anything different to say for one side or the other. Now, of course, bias is alive. We know it exists. We know about allegiance factors. They do exist, but the principle here just says you need to focus on yourself and see if you're being consistent with the science, teaching, and practice of forensic psychology. And we'll talk about some ways to do that, and then we'll get some questions. The
only thing I would add to that is that I think sometimes these situations can be avoided if you're paying attention to what the lawyer tells you. I mean, how many of us have heard a lawyer say, "Doc, you gotta help me," or "You're the only thing I've got"? Those are the sorts of things that really tug at us and want us to help when, in fact, the science may just not be there.
And that's it. That's the bottom line, right? Sorry. I mean, I understand you're desperate in your role of advocacy for your client. I get it. That's your job, but that's not my job.
And it's not my problem either.
It's not my problem, right? And you may not get hired again. Okay. I mean, that's just the reality of being a scientific expert. Impartiality and fairness when offering expert opinions to be relied upon by a decision maker, providing forensic therapeutic services or teaching or conducting research. Forensic practitioners strive for accuracy, impartiality, fairness, and independence. Forensic practitioners recognize the adversarial nature of the legal system and strive to treat all participants and weigh all data, opinions, and rival hypotheses impartially. This is an interpretation of the ethics code again, principle 2.01, but it's expanded to apply to forensic psychology. When conducting forensic examinations, forensic practitioners strive to be unbiased. This is Anthony's area, and impartial. I'm not sure it's achievable, but you can only do your best. And avoid partisan presentation on unrepresentative, incomplete, or inaccurate evidence that might mislead finders of fact. The guideline does not preclude forceful presentation of the data and reasoning upon which a conclusion or professional product is based. So I actually like that last sentence because it basically says that if you strongly believe that the MMPI-3 was really misused, you have a right to say that, and even if it becomes passionate, that's not necessarily a violation of anything. Or if alcohol use and blackout pass out, as it's relevant to a case material, you can present that passionately. So where does this?
The only thing I would add to that is that I think that last sentence is also relevant when testifying, because I think a lot of times people tend to become somewhat deferent or passive when it comes to cross-examination. And sometimes cross-examination really requires us to do exactly what that says, which is to clarify our testimony and do so forcefully and explain it, whether the cross-examiner likes it or not.
Agreed. You got this. This is your slide.
Okay, we are finally at the end, and hopefully we've left a little time for discussion. So here are some things for you to think about, which are sort of a compilation of of some of these issues that we've worked on for many years. So the first is never worry alone. In other words, if you find yourself in a situation where you anticipate a conflict, the first thing you do not do is worry alone. And the reason is because of the whole issue of bias and the mere fact of wanting to acquiesce and to please. Never worry alone. Number two, that means get consultation. Now, I think that one of the things our friend Mitch Handelsman is fond of saying when you seek consultation is to seek consultation from someone you hate. Now, he's joking. He doesn't literally mean that, but what he does mean is that you don't want to you don't want to seek consultation from someone who knows you and likes you and thinks you would never do anything wrong. You need to seek consultation from someone who is arm's length to the situation and to you in order to, number three, help you think through all of the alternatives that you possibly can in terms of how to address the issue. And I think we've tried to suggest there are numerous alternatives, and you need to be able to think those through in order to decide what will work best for you, for the case, and obviously for our obligations to the ethics code.
Yeah, let me speak briefly about consultation. You know, the standard of care is wrapped around the concept of reasonable practice. And so by obtaining consultation, you are getting other people's opinions about a certain type of conduct. And so that becomes arguably more likely to be the standard of practice. If I addressed this issue, I talked to Mike and I talked to Anthony, that's three individuals. That's 3 times better than me doing it alone. But it helps create the argument that it's consistent with the standard of practice. I'm a risk manager. My job is in that capacity to try and get individuals to avoid being into trouble. So consultation is so very important. It doesn't have vicarious liability. It means you can't get sued being a consultant. And so it helps with the standard of practice. Mike, sorry.
That's okay. 2 quick ones. So then once you've obtained the consultation and you have the alternatives, take time to sleep on it. There's usually no rush in these situations. Every once in a while, you have to make game time decisions, and that can be a problem. But in general, that's not the case. Generally, you have time to think about these things. And in my role as a consultant, sometimes I've had people call me back after we've gone through those first few steps and said, hey, wait a minute, I thought about something else. What about this? Great. So sleeping on it and taking time to think things through is always a good idea. And obviously,
there is no such thing as a legal emergency. You know what I mean? Emergency rooms are where emergencies are. You can feel pressure from a lawyer and, oh my God, I have to get this paperwork in. There's no such thing as a legal emergency. So sleeping on it is, slow the train down.
Exactly. And then, of course, the bottom line, which I think is fairly obvious, is that you really have to be aware of how you feel, and especially with regard to the concern of loyalty conflicts and how those may be an impediment to good outcomes. In other words, if you realize that you're feeling pressure from the lawyer and you realize it could be an impediment, that's where you put your finger on the problem.
Okay. I think we're at the end of the road. Here's some references by some mild-mannered people. Mike and I have written a lot about this, and we're happy to provide you with those articles if you'd like. And here is the QR code link for whatever that's supposed to do for you. And I think, Anthony, we're at the end of the presentation.
Yeah, I think Mike, you were concerned about perhaps you might run too early. Jeff saying going over. That's pretty perfect timing. Thank you both for this discussion. You can see that we have several questions in here already. I really appreciate when discussing consultation, adding for our people here, not just the idea of consulting, but when, how you would actually do this, the considerations that go beyond mere the verb of doing so. Everybody that the APA CE credits, if you're pursuing those, that link is in the chat. Make sure that you check that before you leave. You can continue to enter questions in the chat. I'll do the best that I can. A lot of these are praise for both of our presenters. So I'll be happy to share some of those if you want, but otherwise you can feel free to read through those. But
I like praise. I like praise, though.
You like praise? All right. I've got a couple of good ones in there for you.
That always scares me.
Yeah. So and just at the end here, the discussion outstanding, both made complicated issues blessedly clear and understandable. Thank you both. People really appreciated the dynamic here of having a back and forth conversation about these issues, that it was very important and much appreciated. Somebody asked your opinion on an evaluator conducting forensic evaluations through a state hospital system full-time, who also conducts evaluations through a private practice that can be defense hired and often conflicts with their colleagues within the state hospital.
Mike, you look like you have an aha on your face. So go ahead.
I'm having a thinking. All right, let me make sure I understand the question. So I work full-time for the state hospital doing evaluations, I assume, for the government. And then I also have a side hustle where I'm doing evaluations on the defense side as well. And those might conflict with the testimony of some of my colleagues. Do I understand correctly?
Yes, at the state hospital, you're doing state ordered evaluations, and then your private practice primarily defense.
Okay, well, my vote is always to go upstream as far as possible and start with, where are my obligations? Who's my client? Who am I responsible to? Now, obviously, if the hospital is paying my salary, that's where I have to start and go to my boss and say, hey, I've been approached, to do these other evaluations. Do you have any concerns about that? So that's step one. If in fact the boss doesn't have any problem, then the question, I think, becomes more interpersonal. In other words, are you going to feel uncomfortable, if you find yourself on the witness stand opposing the colleague who you office next door to? So I don't know that there's necessarily anything unethical about that per se, but as we're fond of saying, the fact that something isn't unethical doesn't necessarily make it a good idea. So I don't really see this half so much as an ethical issue as that I do a one of, as I do one of, do you really think this is a good idea? If you're not concerned about, how your colleagues feel about you, that may be less of a problem. But I think the issue really is to clarify all this at the outset, especially with your employer. Jeff,
I think you make a really great point, is that some things are just not a good idea. They're not a violation of ethics or the law. It just is not a good idea, and so you have to try and manage them. And the problem is, frequently in our area, we don't know it's a problem until we're way down the road, and we've gotten ourselves in that pickle. But then you have to manage it. So that's consistent with both the specialty guidelines and the ethics code. Okay.
Thank you. Somebody noted earlier in the presentation, independence provided by who hired you in military courts is fascinating. Would it be reasonable for psychologists to ask for the court to hire an expert psychologist, neither the plaintiff or defense? Would that help with potential conflict?
I noticed that Gordon did that. That's his question, and it's a great question. I believe yes. I really liked when I worked in the military courts and somebody would say, we have a sexual assault case or an alcohol or murder. It doesn't make any difference. And these are the dates of the trial, and we need an expert. Can you make those dates? That they aren't asking about what's the substance of the case. You kind of get to know a little of it, but you don't know which side you're working for. And I think that is that's very helpful. In my experience of having done so many military trials, not all of them, sometimes you know what you're hired for, but frequently not, that it just is like you're on the defense. And so then you work the defense, or you're on the prosecution and you work the prosecution. So it's helpful. So I think it's a great question, Gordon.
I agree. I just think in the civilian world, it's not very realistic.
No.
I've done military cases as well, and I agree completely with Jeff. I really love that, how that system works. But the practical reality is that usually defense lawyers are the ones who are going to want to hire experts. and they have the ability to do so. And judges do not do this on their own. Now, every once in a while, a prosecutor may hire someone, for example, in a murder case, for example, they may. But part of the problem is they don't have the funds. But at least where I live, judges don't take the initiative to do this. They just don't.
Someone brought up a scenario here of your thoughts on a psychologist who's hired by one party in a custody matter, sees the whole family together and individually, telling them it's therapy to help their relationship, and then writes a report supporting the party that retained them. Obviously, there's an issue with lack of informed consent, but they often do not perceive this as a multiple relationship as well. What say you?
Oh, well, what I say is that sometimes it's hard for some people to avoid a professional death wish. And they insist upon destroying their careers and losing their licenses and getting themselves, ground up in a meat grinder. This is the highest risk area of professional practice. Adversarial, in my work with the trust, constantly get calls about this. So keep your role simple. It's adversarial anyway. And the more you make your role complex, the more you cloud these issues, the more you're going to find that adversarial nature frequently will take its way right into the licensing board, who will have some strong feelings about that. You shouldn't be involved in treatment. That word is inappropriate if you're functioning as a forensic expert.
I have nothing to add.
Speechless. Okay.
No, you said it all.
I'm going to read this question as it is with the colorful language and all, since I know that it's your friend and colleague here that said very early on when you talked about dual relationships, as your point is so obviously true, you have written clearly and extensively about it. So why in the world do you think that so many people think that a dual relationship is automatically unethical?
This is Joel's question.
Of course.
I thought he was making trouble. Go ahead. I've got an answer for it.
I don't. Well,
I can make up an answer here, but I really think that it's kind of like become a thing that lives on its own. That the term dual relationship is equal to unethical. It's like saying cancer is equal to death. Not correct. It's not correct. And so it's a gross oversimplification. Joel's correct. I actually think we need to get graduate training programs to tone down the regulations that they kind of spout out that produce young psychologists who are gun shy. And it concerns me. All right, now you're going to say.
I really worry that some of this is not necessarily our fault. When I teach ethics at UT Southwestern, and during my first lecture, I explained that people have a very difficult time with cognitive processes when they're anxious. And when you're anxious, you can't think. Well, part of the problem is that a lot of our colleagues go to ethics workshops, so to speak, often given by lawyers, where that's exactly what happens, where they're told to be afraid. And as a result, out of an abundance of caution, they adopt these rather extreme positions. At least that's my thought. Jeff, you got another idea?
I don't disagree with it. I don't disagree with it. It's oversimplification. It's a complex area. I mean, we've written about it. It's not that easy. If it were easy, you just write one-page article, you're done. But it's not. And so yeah, it's not all perfectly clear.
Wonderful. Well, thank you so much, Mike, Jeff, for a very engaging, thorough dialogue on all these different ethical issues that we can consider, and kind of a reassurance too of how we can approach these considerations when there could potentially be a dual relationship, a multiple relationship, and how we might approach that in the future. That wraps up this week's Law and Mental Health series. We will keep you posted on a potential talk next week. And until then, we hope to see you then, and take care.
Thank you.
Thank you.
Absolutely a pleasure.